I was standing on my dock watching the sunrise over Lake Martin when I noticed three strangers backing a fishing boat down my private ramp. Not one of them looked my direction as they expertly maneuvered the trailer into the water, completely at ease, like they owned the place. I had owned this waterfront property in Alexander City, Alabama for almost 15 years, and in all that time, I had never seen these people before in my life. "Hey!" I called out, jogging down the weathered boards toward them. "What are you doing?" The oldest of the three, a grizzled man in his 60s with a trucker cap, looked at me with confusion rather than guilt. "We paid for access, got it through the Willow Creek HOA. They said we could use this ramp any time." My jaw dropped. "The what? This is private property. My property." The man pulled out his phone, tapped it a few times, and showed me a receipt. Sure enough, there was a payment confirmation for $200 to the Willow Creek Homeowners Association for seasonal boat ramp access at my address. The transaction was dated just 2 weeks ago. "Look, buddy, I don't know what's going on between you and your HOA, but we paid good money for this," the man said, his tone shifting from friendly to defensive. "We're not looking for trouble." I ran my hand through my hair, trying to process what was happening. My property isn't part of any HOA. Never has been. Someone's running a scam, and you're caught in the middle of it. The three men exchanged glances. The youngest one, probably in his 30s, spoke up. The lady we talked to seemed real professional, had all these documents about the community access program, said it was all legal and above board. "What lady?" I demanded. "Karren something. Karren Whitmore, I think. She's the HOA president, had an office set up at the community center off Highway 63. My blood ran cold. I knew exactly who Karren Whitmore was. She lived 4 houses down from me in what she insisted was a planned community, despite the fact that most of us had bought our properties independently decades ago. She had been trying to force an HOA on our neighborhood for the past 3 years, sending certified letters claiming we were all subject to covenants and restrictions that, as far as I knew, did not exist. My name is Michael Quincy, and I'm a patent attorney. I make my living understanding property rights, documentation, and legal precedent. If anyone tried to pull something over on me regarding property ownership, they picked the wrong target. "Give me a minute," I told the fisherman. "I need to make some calls. But I'm telling you right now, you've been scammed." I walked back to my house, a modest 2-story cabin with floor-to-ceiling windows facing the lake. The place had cost me a fortune back in 2011, but it was my sanctuary. I had specifically chosen this property because it came with direct water access and a private boat ramp. The previous owner had been meticulous about the property boundaries, and when I bought it, everything was surveyed and documented down to the inch. Inside, I headed straight for my home office and pulled out the fireproof box where I kept all my important documents. The original land survey was right on top, a thick document with precise measurements, legal descriptions, and most importantly, a note that the property had been specifically excluded from any homeowners association restrictions when the previous development had gone in back in 1987. I had always kept this document close because Karren had been such a persistent thorn in my side. She had tried everything to make me join her little kingdom, threats of fines, claims about property maintenance violations, even an attempt to put a lien on my house last year. Each time I had shut her down with documentation proving my property was sovereign, separate, and completely outside her jurisdiction. But selling access to my boat ramp? That was a new level of audacity and potentially a new level of illegal activity. I grabbed my phone and called my lawyer, David Chen, who also happened to be a close friend from law school. He answered on the 3rd ring. "Michael, it's 6:30 in the morning. This better be good. Karren Whitmore is selling access to my boat ramp to the public. I've got 3 guys here right now with a receipt showing they paid $200 to the Willow Creek HOA. There was a long pause. "She's charging people money to use your private property?" "Apparently so. And based on this receipt, it's not a one-time thing. It says seasonal access, which means she's probably got a whole list of people who think they can use my ramp whenever they want." David whistled low. "That's fraud at minimum, possibly theft by deception, definitely trespassing facilitation. Do you still have that original survey that excludes you from the HOA? Got it right in front of me? Okay, here's what we're going to do. First, Take photos of those guys and their receipt. Get their names and contact information. Tell them to contact the police and file a fraud report. Second, you're going to march down to Karren's house right now and inform her that if she doesn't immediately cease this operation and refund every penny to everyone she scammed, you'll be filing both criminal complaints and a civil lawsuit. Third, we're going to send a cease and desist letter to the HOA by end of business today. What if she doesn't stop? Then we bury her in legal action. Michael, this isn't just a property dispute anymore. She's actively defrauding people for financial gain. If we can prove she's collected money from multiple people, this becomes a serious criminal matter. I thanked David and headed back outside. The three fishermen were still there, now sitting on the dock looking uncomfortable. I approached them with my phone out. Gentlemen, I need your names and contact information. I also need to photograph that receipt. You've been defrauded, and I'm going to help you get your money back. The older man, who introduced himself as Robert Hayes, looked resigned. We should have known it was too good to be true. Most private ramps charge a lot more, and the public ones are always crowded. When this Karren lady said it was a community sharing program, we thought we were getting a deal. How many other people did you see at her office? I asked. Maybe a dozen when we were there last Saturday. The younger man, Trent Hayes Roberts' son, answered. There was a waiting area and it was pretty full. She had this whole presentation about community values and sharing resources. Did she show you any actual proof that she had authority over this property? They looked at each other and shrugged. She had papers, Robert said. Legal-looking stuff. We didn't read it all that carefully. Just signed the access agreement and paid. I took down all their information and strongly suggested they file a police report for fraud. They agreed, though they seemed more embarrassed than angry. After they left, I stood on my dock for a moment, watching the sun climb higher over the water. The morning had started so peacefully, and now I was dealing with what could turn into a major legal battle. But if Karren wanted a fight, she was going to get one. I walked down the gravel road toward her house. The neighborhood, if you could call it that, was really just a collection of lakefront properties along a half-mile stretch of shoreline. Some houses were year-round residences like mine. Others were vacation rentals or weekend getaways. There was no unified architecture, no common amenities, no reason for an HOA to exist, except in Karren's imagination. Her house was a massive modern monstrosity that she and her husband had built 5 years ago, all sharp angles and glass panels that seemed completely out of place among the rustic cabins and ranch-style homes. A BMW SUV sat in the circular driveway, and I could see lights on in what looked like a home office on the ground floor. I rang the doorbell 3 times in quick succession. Karren answered the door in yoga pants and a designer sweatshirt, her blonde hair pulled back in a perfect ponytail. She was probably in her early 50s, but spent enough on treatments and procedures to look 40. Her expression went from annoyed to hostile the moment she saw me. Michael, it's not even 7 in the morning. What do you want? I want you to stop selling access to my boat ramp. Her eyes widened for just a fraction of a second before her face settled into a mask of innocence. I have no idea what you're talking about. Really? Because I just had 3 people show up at my property with a receipt from the Willow Creek HOA showing they paid $200 for seasonal boat ramp access. My boat ramp, Karren. On my private property, she crossed her arms. The community access program is completely legal. All waterfront properties in this development are subject to shared amenity clauses in the original plat documentation. Show me. Excuse me? Show me the documentation, right now. Show me where it says my property is subject to any shared amenity clauses. Karren's lips pressed into a thin line. I don't have to show you anything. The HOA has legal counsel, and everything we do is reviewed and approved. If you have a problem, you can file a formal complaint with the board. There is no board, Karren. There's you, pretending to run an organization that has no legal authority over my property or anyone else's. I have the original land survey, excluding my lot from any HOA restrictions. I've had it since I bought this place. You know I have it because I've shown it to you before. That survey is outdated. The covenants were updated in 2019. No, they weren't. You can't create retroactive covenants without unanimous agreement from all property owners, and I sure as hell never agreed to anything. What you're doing is fraud, Karren. You're collecting money from people for access to property you don't control. That's a crime. Her face flushed red. How dare you come to my home and accuse me of criminal behavior? I am the HOA president. I was elected by the community. What community? The 4 other people who show up to your fake meetings? Karren, this ends now. You're going to contact every single person you sold ramp access to, refund their money, and shut down this scam immediately. If you don't, I'm filing criminal complaints with the police and civil suits that will cost you more than whatever you've managed to collect. Get off my property, she hissed. Gladly, but you've been warned. Cease and desist or face the consequences. I turned and walked away, my heart pounding. I dealt with difficult opposing counsel in patent litigation, faced down corporate legal teams with unlimited budgets. But something about Karren's absolute conviction in her own authority made her more infuriating than any of them. Back at home, I called David again to update him. He had already drafted the cease and desist letter and promised to have it sent via certified mail and email within the hour. He also suggested I contact the local police non-emergency line to report the fraud and establish a paper trail. The Alexander City Police Department was polite, but not particularly enthusiastic when I explained the situation. The desk officer took my information and said someone would follow up, but I got the distinct impression that HOA disputes were low on their priority list. I understood. Without evidence of substantial financial harm or a clear victim willing to press charges, it probably seemed like a civil matter better left to lawyers. But I was patient. I knew how these things worked. The key was documentation and building a case methodically. Over the next week, I did exactly that. I set up a camera system overlooking my boat ramp and caught 17 different vehicles attempting to use it. Each time I walked down, explained the situation, and collected information about how they had purchased access from Karren. The amounts varied. Some paid $200 like the first group. Others had paid as much as $500 for what was described as premium seasonal access. Every single person showed me receipts, access agreements, and promotional materials from the Willow Creek HOA. Karren had created an entire website, complete with stock photos of happy families enjoying lake activities, testimonials that were clearly fabricated, and a rate structure for different levels of access. She had even registered the HOA as an LLC with the Alabama Secretary of State, giving it a veneer of legitimacy. The more I dug, the more sophisticated the scam became. Karren had not only been selling boat ramp access, but also charging some homeowners in the area annual dues for services the HOA supposedly provided. When I contacted 3 neighbors who appeared on the HOA's member list, they all told similar stories. Karren had approached them with official-looking documents claiming they were required to join the HOA and pay dues. 2 of them had paid rather than deal with the hassle. 1 had refused and been threatened with legal action that never materialized. By Friday, I had documented nearly 40 victims and over $15,000 in fraudulent charges. David was salivating over the case. This was no longer a simple property dispute. This was organized fraud on a scale that would definitely interest law enforcement. We filed a comprehensive police report with all the documentation I had gathered, along with a formal complaint with the Alabama Attorney General's office. David also filed a civil suit on behalf of myself and, with their permission, 12 of the people Karren had defrauded. We were seeking restitution, punitive damages, and an injunction permanently barring her from claiming any authority over our properties. The following Monday, I got a call from Detective Lisa Morrison of the Alexander City Police Department. She wanted to meet with me to discuss the case. We arranged to meet at a coffee shop downtown that afternoon. Detective Morrison was in her 40s, sharp-eyed and professional. She had reviewed all the documentation I had submitted and had some additional questions. We sat in a corner booth, and she pulled out a notebook. "Mr. Quincy, I have to say, this is one of the more interesting cases I've seen in a while. Mrs. Whitmore has essentially created a fake HOA and used it to collect money for services and access she has no authority to provide." "That's exactly right," I said. "And the thing is, she's been trying to establish this HOA for years. I think she genuinely believes she has some kind of authority, but that doesn't change the fact that she's taking people's money under false pretenses." We contacted Mrs. Whitmore this morning. She insists everything she's doing is legal and that she has proper documentation. She's retained an attorney. Good. Let her waste her money. I have the original land survey that explicitly excludes my property from any HOA restrictions. I'm happy to provide copies for your investigation. Detective Morrison nodded. I've already requested that. I'm also going to need to interview some of the people who paid for boat ramp access. Would you be able to provide me with their contact information? Absolutely. I have a spreadsheet with everyone I've spoken to, including dates, amounts paid, and copies of their receipts. You've been thorough. I'm a patent attorney. Documentation is what I do. She allowed herself a small grin. That works in our favor. Based on what I've seen so far, I believe we have enough for charges of theft by deception. Depending on how much money she's collected overall, we might be looking at felony charges. But I need to complete the investigation first. Over the next 2 weeks, Detective Morrison worked her way through the victim list. Karren, meanwhile, went on the offensive. She sent a mass email to everyone on her HOA mailing list, claiming I was harassing her and trying to destroy the community. She accused me of being selfish and hostile to the neighborhood. She even sent a formal complaint to the Alabama State Bar, suggesting I was using my position as an attorney to intimidate her. The bar complaint went nowhere. I had been careful to act as a private citizen protecting my property rights, not as an attorney representing myself. But the email campaign did cause some tension. A couple of neighbors who had drunk Karren's Kool-Aid started giving me dirty looks when I drove by. I did not care. I had the law on my side, and more importantly, I had the truth. The civil case moved forward rapidly. Karren's attorney, a local general practitioner named Greg Hoffman, seemed to realize pretty quickly that he was on the losing side. In our first mediation session, he barely defended Karren's position. When I presented the original land survey, the website screenshots, the receipts, and testimony from victims, he looked like he wanted to crawl under the table. My client believed she was acting within her authority as HOA president, he said weakly. Your client created a fictional HOA and used it to commit fraud, David countered. The question isn't whether she believed she had authority. The question is whether she bothered to verify that authority before taking people's money. And the evidence clearly shows she did not. We eventually reached a settlement. Karren agreed to refund every penny she had collected, pay an additional $10,000 in damages to me for the unauthorized use of my property, and sign a permanent injunction admitting she had no authority over my property and agreeing never to claim such authority again. The total hit to her bank account was over $30,000, but the criminal case was far from over. In late March, Detective Morrison called to inform me that the investigation had expanded. After my complaint went public, 6 more people came forward claiming they had paid Karren for various HOA services. One couple had paid her $3,000 for what she described as architectural review fees before building a deck. Another homeowner had paid regular monthly dues for 2 years, totaling nearly $5,000, believing it was required for road maintenance that never happened. The total fraud amount now exceeded $50,000. In Alabama, theft by deception over $2,500 is a Class B felony, punishable by 2 to 20 years in prison. Karren was looking at serious time if convicted. The arrest happened on a Tuesday morning in early April. I was not there to see it, but my neighbor Tom Patterson called me immediately afterward. Tom was one of the few people in the area who had refused to have anything to do with Karren's HOA from the beginning. Michael, you're not going to believe this. Police just hauled Karren out of her house in handcuffs. There were 2 squad cars and an unmarked detective vehicle. Her husband looked like he was going to have a heart attack. I felt a grim satisfaction. She brought this on herself. I know, but still, it's wild. This whole neighborhood is going to be talking about nothing else for months. He was not wrong. The local newspaper, the Alexander City Outlook, ran a front-page story about the arrest. The headline read, "Local HOA, President Charged with Felony Fraud." The article detailed the charges and included a statement from the police department about the investigation. My name was mentioned as the complainant who had initially brought the fraud to light. Karren's attorney arranged bail, and she was released the same day. But the damage was done. The story spread through the community like wildfire. The few people who had supported her HOA efforts quickly distanced themselves. Her husband, a quiet accountant named Richard, looked absolutely mortified every time I saw him in town. The preliminary hearing was set for mid-May. David and I attended, along with Detective Morrison and several of the victims. Karren showed up in a conservative navy suit, her face drawn and pale. Her attorney had been replaced by a criminal defense lawyer from Birmingham, a sharp woman named Patricia Sanderson, who had a reputation for getting charges reduced or dismissed. But even Patricia could not work miracles when the evidence was this overwhelming. The prosecutor, Assistant District Attorney James Walsh, presented a devastating case. He had the receipts, the bank records showing deposits to Karren's personal account from the HOA LLC, testimony from victims, and most damningly, my original land survey proving she had no authority to sell access to my property. Patricia tried to argue that Karren had made an honest mistake, that she genuinely believed she was acting within her rights as HOA president. But when Walsh presented the website, the promotional materials, and the detailed pricing structure, that defense fell apart. This was not a mistake. This was a deliberate, sustained effort to collect money. The judge, a stern woman in her 60s named Barbara Chen, reviewed the evidence and ruled that there was sufficient probable cause to proceed to trial. She set the trial date for July and reminded Karren that violating the terms of her bail would result in immediate incarceration. As we left the courthouse, Patricia Sanderson pulled David aside. I stayed close enough to hear their conversation. "Your client has a very strong case," she said quietly. "Between us, I'm going to advise Mrs. Whitmore to consider a plea agreement. If this goes to trial, she's looking at a felony conviction and possible prison time." "That's between you and the prosecutor," David said. "But yes, the evidence is conclusive. My client just wants this resolved in assurance that his property rights will never be challenged again." "Understood. We'll be in touch." Over the next few weeks, negotiations happened behind the scenes. Patricia reached out to the prosecutor with a proposed plea deal. Karren would plead guilty to a reduced charge of misdemeanor theft by deception, pay full restitution to all victims, perform 200 hours of community service, and accept 2 years of probation. In exchange, the felony charges would be dropped. It was not everything I wanted. I would have preferred to see her face felony consequences. But Walsh explained that the plea deal guaranteed restitution for the victims and avoided the uncertainty of a trial. If a jury somehow acquitted her, the victims would have to pursue civil remedies, which could take years. Reluctantly, I agreed that the plea deal was acceptable, as did the other victims David had contacted. In early June, Karren appeared before Judge Chen to formally enter her plea. The courtroom was sparsely populated, just Karren, her attorney, her husband, the prosecutor, a few victims, David, Detective Morrison, and myself. Karren stood before the judge, her voice barely above a whisper as she admitted guilt. "Mrs. Whitmore," Judge Chen said sternly, "you have admitted to using a fabricated homeowners association to defraud your neighbors and members of the public. You collected money for services you had no authority to provide and for access to property you did not own. This is a serious breach of trust and basic honesty. While I am accepting this plea agreement, I want you to understand that any violation of your probation terms will result in prosecution on the original felony charges. Do you understand?" "Yes, Your Honor," Karren said, her voice cracking. "You will pay full restitution as outlined in the agreement. You will complete 200 hours of community service. You will not claim any authority over any property in your neighborhood or establish any homeowners association without explicit, documented consent from every property owner involved. If I hear your name in my courtroom again for anything resembling this conduct, I will throw the book at you. Am I clear?" "Yes, Your Honor." Judge Chen signed the plea agreement, and just like that, it was over. Karren was escorted out by her attorney, avoiding eye contact with everyone. Her husband trailed behind her, looking shell-shocked. Outside the courthouse, Detective Morrison shook my hand. "Thank you for bringing this to our attention, Mr. Quincy. A lot of people were being taken advantage of, and without your documentation, we might not have been able to build such a strong case." "I was protecting my property," I said, "but I'm glad it helped others too." David and I went to lunch at a local barbecue place to celebrate. It felt strange to celebrate someone else's downfall, but I could not deny the satisfaction of seeing justice served. "You know what the best part is?" David said, tearing into a rack of ribs. "She has to personally contact every victim and arrange restitution. That means dozens of conversations where she has to admit what she did and apologize. That might be worse than the community service. I raised my sweet tea and a mock toast to getting our pound of flesh." Over the following weeks, Karren made good on the restitution payments. I received a check for $10,000 along with a stiff formal letter acknowledging that my property was not subject to any HOA authority and apologizing for the unauthorized sale of access. The letter was clearly written by her attorney, but it was signed by Karren. I also heard through the neighborhood grapevine that she and Richard were planning to sell their house and move. The shame and legal troubles had made living in the area untenable. Part of me felt a twinge of sympathy her life had imploded over this, but I reminded myself that she had brought it entirely on herself. She had ignored clear evidence that she had no authority, fabricated an organization, and taken money from people under false pretenses. The consequences were earned. By the end of July, a for sale sign appeared in front of Karren's glass monstrosity. The asking price was steep, but lakefront property always sold eventually. I did not see her much after that. When our paths did cross, she looked right through me as if I did not exist. The boat ramp, meanwhile, returned to its intended use, my private access to Lake Martin. I had no more surprise visitors, no more angry confrontations, no more fraud schemes, just peaceful mornings on the water, exactly as it should be. Tom Patterson stopped by one evening with a six-pack of beer. We sat on my dock watching the sunset paint the lake in shades of orange and purple. "You know, you're a hero in this neighborhood now," Tom said, taking a swig. "Half the people here were terrified of Karren and her fake HOA. They didn't know how to fight back. You showed them it was possible." "I just enforced my property rights," I said. "Anyone could have done it." "But they didn't? You did. And you had the documentation to back it up. That land survey was like your secret weapon." I thought about that. The survey had indeed been the key to everything. Without it, Karren could have continued to claim ambiguity about HOA boundaries, dragging the case out in endless legal wrangling. But with that clear, documented exclusion from HOA restrictions, there was no wiggle room. The facts were the facts. "Always keep your paperwork," I said, "especially when it comes to property. People will try to take advantage if they think you can't prove ownership or rights." Tom nodded thoughtfully. "I'm going to dig out my old property documents this weekend, just in case." In August, the house sold to a young couple from Montgomery who were looking for a weekend retreat. They introduced themselves shortly after moving in, friendly and excited about lake life. I mentioned casually that there was no HOA in the area and never had been. They seemed relieved. "We just got out of an HOA nightmare in our old neighborhood," the husband said. "Rules about paint colors, grass height, where you could park your car. We wanted freedom, you know." "You'll find plenty of that here," I assured him. Life returned to normal. I went back to focusing on my patent cases, taking calls from my home office with the lake as my backdrop. I took my boat out regularly, enjoying the privacy and peace I had fought to protect. The whole ordeal with Karren became a story I told at dinner parties, a cautionary tale about the importance of documentation and the dangers of unchecked petty authority. But the saga had one final twist I did not see coming. In September, I received a letter from an attorney in Montgomery representing the Alabama Attorney General's Consumer Protection Division. They had reviewed the case against Karren Whitmore and wanted to use it as the basis for new guidance on HOA formation and authority in the state. They asked if I would be willing to participate in a working group to develop clearer regulations and protections for homeowners. I agreed immediately. If my experience could help prevent others from falling victim to fake HOAs or overzealous neighborhood dictators, it was worth my time. The working group met monthly in Montgomery. It was composed of attorneys, consumer advocates, real estate professionals, and homeowners who had dealt with HOA issues. We developed recommendations for stricter registration requirements for HOAs, clearer disclosure rules for property sellers, and stronger penalties for fraudulent HOA claims. The work was tedious but important. We drafted model legislation that was eventually introduced in the state legislature. While I do not expect it to pass quickly, nothing moves fast in politics, it was satisfying to know that something positive could come from the whole mess. One of the other working group members, a real estate attorney named Helen Martinez, became a good friend. She had dealt with numerous HOA disputes in her practice and was passionate about reforming the system. The problem is that HOAs can be genuinely useful when properly run, she explained over coffee after one of our meetings. They can maintain common areas, enforce reasonable standards, and protect property values. But when someone like your Karren Whitmore comes along and abuses the structure, it poisons the well for everyone. So what is the solution? I asked. Transparency and accountability, mandatory audits, clear election procedures, accessible records, and real penalties for fraud. Most states, including Alabama, have let HOAs operate with minimal oversight. That needs to change. I could not agree more. By the time autumn rolled around, the leaves changing from green to brilliant reds and golds, I felt like I had finally closed the chapter on the HOA fiasco. Karren and Richard had moved to somewhere in Georgia, according to Tom. The new neighbors were delightful. My boat ramp remained private and unmolested. The legal bills had been substantial, but the settlement and damages had covered most of it. More than that, I had proven a point. Property rights matter. Documentation matters. Standing up to bullies, even those who cloak themselves in official-sounding titles, matters. Karren had tried to create her own little kingdom, and I had torn it down with nothing more than facts and determination. On a crisp October morning, I stood on my dock with a cup of coffee, watching the mist rise off Lake Martin. A blue heron landed on the ramp, completely unconcerned by my presence. It stood there for a moment, statuesque and patient, before spearing a fish from the shallows and taking flight. I raised my coffee cup in salute. Life was good, the lake was mine, and Karren Whitmore was someone else's problem now. The one lingering question was whether she had learned anything from the experience. I doubted it. People like Karren rarely accepted personal responsibility. They always found ways to blame others, to justify their actions, to paint themselves as victims. She probably told herself that I was the villain, that the legal system was unfair, that she had been persecuted for trying to improve the community. But that was her burden to carry, not mine. I had my property, my peace, and my principles intact. That was all I needed. As winter approached and the lake took on the stark beauty of bare trees and gray skies, I found myself reflecting on how the whole situation had unfolded. It had started with 3 confused fishermen on a Sunday morning and escalated into a criminal case that exposed years of fraudulent activity. If I had not been home that morning, if I had not confronted those men, if I had not had the original land survey, how much longer would Karren's scheme have continued? David and I discussed it over drinks one evening at his house in Birmingham. I had driven up for a Crimson Tide game, and we were sitting in his den watching the replay. "You got lucky in some ways," David said. "Having that survey, being an attorney yourself, knowing how to document everything properly, most homeowners would have been steamrolled." "That's what bothers me," I admitted. "How many other Karens are out there doing the same thing? How many people are paying fake HOA dues or fees for services that don't exist because they don't know how to fight back?" "More than you want to know about. HOA disputes are a huge part of real estate litigation. Most of them are legitimate HOAs overstepping their authority, but I've seen cases of outright fraud too. Yours was just particularly brazen. At least we got her on record. That plea agreement is public. If she ever tries something like this again, there's a paper trail." David raised his beer. "To paper trails and the attorneys who create them." We clinked bottles and turned our attention back to the game. The holidays came and went. Christmas on the lake was magical, with snow dusting the pines and the water reflecting the winter sky like polished steel. I hosted a small gathering for neighbors, including the new couple who had bought Karren's old house. They fit into the community far better than she ever had, friendly and respectful without any pretense of authority. As the new year arrived, I made a resolution to let go of the anger and frustration that had built up during the HOA battle. Holding on to that negativity was not healthy, and the situation was resolved. Karren had faced consequences, the victims had been made whole, my property was secure, but I also resolved to stay vigilant, Property rights are not something you can take for granted. They require active protection and clear documentation. I updated my property records, made digital copies of all my important documents, and shared my story with anyone who would listen. If I could help even one person avoid a similar situation, it would be worth the retelling. In February, I received a notification that Karren had completed her community service requirement. She had been assigned to work at a local food bank, sorting donations and helping with distribution. I wondered what that had been like for her, someone who had been so focused on authority and status, reduced to serving others in such a humble capacity. Maybe it had been good for her soul, or maybe she had resented every minute of it. Either way, it was no longer my concern. The spring brought new life to the lake. The trees budded, flowers bloomed, and the water warmed enough for swimming. I spent weekends on my boat exploring the coves and inlets of Lake Martin, appreciating the freedom and beauty of the place I called home. One Saturday afternoon, I was cruising near the dam when I spotted a familiar BMW SUV parked at a public boat ramp on the far side of the lake. Karren and Richard were launching a small fishing boat, working together in tense silence. Richard handled the trailer while Karren sat in the driver's seat, looking miserable. I considered waving or saying something, but what would be the point? The past was the past. Instead, I steered my boat away, giving them space. Whatever demons Karren was wrestling with, she had to face them on her own. As I headed back toward my property, the sun warm on my face and the wind in my hair, I felt a deep sense of gratitude. Not just for the resolution of the HOA situation, but for the life I had built. The lakefront property, the career that allowed me flexibility and independence, the friends and neighbors who supported me, the legal system that, for all its flaws, ultimately delivered justice. I pulled up to my dock and secured the boat, then walked up to my house. The original land survey was still in the fireproof box in my office, a silent guardian of my rights and freedoms. I pulled it out and looked at it one more time, reading the precise measurements and legal descriptions that had been my shield against fraud and overreach. Then I carefully placed it back in the box, locked it, and returned to my life. The story of the fake HOA and the boat ramp scam would eventually fade into local legend, one of those tales that people told newcomers as a warning and entertainment. I had played my role, fought my fight, and won my victory. What more could anyone ask for? As summer arrived and the lake filled with vacationers and boaters, I took special pleasure in using my private ramp whenever I wanted, knowing that every time I backed my trailer down those concrete planks, I was exercising rights that I had defended and preserved. No fake HOA, no petty dictator, no amount of fraudulent paperwork could take that away from me. Michael Quincy, property owner, attorney, and defender of documented truth. It was a good legacy to have, even if it was just in my own mind. One evening in late June, Tom and I were sitting on my dock again, a tradition we had maintained since the whole ordeal began. The sun was setting, painting the sky in those brilliant colors that made Lake Martin famous. We were quiet for a while, just enjoying the peace. "You ever hear from Karren?" Tom asked eventually. "Nope. Saw her at the public ramp once from a distance, that's it. Probably for the best. Some people you're better off never seeing again." Agreed. Tom took a sip of his beer. "You know what I learned from all this? Having good neighbors matters more than having perfect lawns or matching mailboxes or any of that HOA nonsense. Give me freedom and friendship over rules and regulations any day." I smiled. "I'll drink to that." We tapped our bottles together and watched the sun disappear below the horizon, the lake darkening from gold to deep blue to black. Somewhere out there, Karren Whitmore was living her life, dealing with the consequences of her choices. But here, on my dock, on my property, with my friend beside me, everything was exactly as it should be. The fight was over, the victory was secure, and life on Lake Martin continued, beautiful and free.